Welcome to this afternoon's webinar on entertainment and copyright law. This afternoon, we are honored to have with us Sharon Chahale Wata and Liz Lenjo-Kargs. So I'll start off with Sharon's bio. Sharon is an accomplished intellectual property lawyer with 10 years industry experience. She combines legal expertise with intellectual property law knowledge and practice, is an experienced copyright prosecutor, well-versed in plea bargaining techniques and out-of-court settlement negotiations. Additionally, she's experienced in collective management of copyright and training on copyright and generally intellectual property matters. She has excellent skills in administration, management, report writing, prosecution and litigation, as well as facilitation of trainings. Sharon also has past consultancy experience in various areas, including environmental law, human rights, democracy, and governance issues. She delivers projects on time, exceeding expectations of clients, and is recognized as knowledgeable in matters IP law and a credible leader. I'll now move swiftly to Liz Lenjo-Kargs, an advocate of the High Court and founder and managing consultant of MYIP Legal Studio. She specializes in intellectual property, entertainment, media, and fashion law. She's a member of the Copyright Tribunal, the tribunal established under Section 48 of the Copyright Act, Cap 130 of the laws of Kenya. She serves in the Kenya Fashion Council as the head of intellectual property and policy in the legal committee. She's an adjunct faculty member at the Strathmore University Law School, where she teaches media and entertainment law as well as business law. Liz holds a Master of Laws in Intellectual Property Law from the University of Turin, Italy, and World Intellectual Property Organization, a Bachelor of Laws from the Catholic University of Eastern Africa, and a postgraduate diploma from the Kenya School of Law. She also holds a certificate in fashion law from the Fashion Law Institute, Fordham University Law School, New York. This session today will be moderated by myself, Helen Ambassa. I'm the Director, Legal Services at USIU Africa. I'm also a legal and governance specialist. And Ms. Susan Obunga-Guya, advocate who specializes in intellectual property and data protection. We also have our techies behind the scenes. We are working also with Salome Asena. She works here with us at USIU in the School of Graduate Studies, Research and Extension. And we have Mr. Ernest Mwanzi from our Marketing and Communications Office. Thank you and welcome. I'll now move straight away to why we are here today, to generally have a conversation on entertainment and copyright law matters. And the first person to kick us off in this discussion is Sharon Chahale Wata. Sharon, over to you.
Thank you, thank you. Good afternoon, everybody. Good to see you all online. And I'm just hoping that we have an interactive conversation. So this is not exactly a lecture. We lawyers are known to talk a lot, but we want this to be interactive. Send your questions, feel free throughout the session as we talk. If you want something clarified, then you can send it and we can just sort of continue with the conversation. Copyright is wide and big. I hope you can all hear me well. Helen, can you hear me well?
Yes, yes, I can.
Okay. Copyright is wide, and so I thought the place to begin with is just to lay the foundation in terms of the law, what the law says about copyright, what provisions are there. One of the interesting things I've in the recent past come to find out is that copyright is actually, it's considered a fundamental human right, and it actually has provisions within the Universal Declaration of Human Rights, yeah? If I can just shortly read it, it says, everyone has the right to protection of their moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. So you can imagine the Universal Declaration of Human Rights recognizes copyright as a fundamental human right. The Constitution of Kenya, 2010, has also come to recognize intellectual property rights for people in Kenya in different articles. We have Article 11, we have Article 40, Article 69. They all enhance intellectual property, which is something we didn't have before. And then, of course, we have the Copyright Act. We have a recent amendment, which was the amendment of 2019. And so what is copyright? Basically, it's just a legal term that is used to describe the exclusive bundle of rights that creators have over their literary and artistic works, musical works, dramatic works. Basically, the law gives you the right to control the use of your work, to control who can reproduce it, to control who can distribute it, to control who can communicate it to the public. There have been very many different theories on justifying why we should have copyright. Some people look at copyright as let me call it a schoolmaster, ya kukuchapa kiboko, but that is not it. The view should be that copyright is supposed to be a bridge between the creator and the user. So the idea is not necessarily to bar people from accessing this work and using it. The idea is that while people are accessing the work and using it, then the creator is also incentivized to create more, but also receives some reward from what they have created. So you'll find most people clashing with it because one, the user's idea is that they don't want me to access it. And the creator's idea is that I need to get as much as I can out of it, but there needs to be a balance, which copyright essentially tries to create. That while you're using this work, the person who created it is also getting something out of it. So that is the general synthesized idea about it. Copyright gives you two types of rights, basically. I'm sorry, moderator, how many minutes did you give me to do this intro?
You have like 15 minutes for the intro.
Okay.
Yeah.
I just want to pick the most important issues I can pick out from the issue of copyright, and then the rest we will discuss them as the questions come along, yeah? So basically, copyright gives you two rights. One is called moral rights. Moral rights basically is one, the right to attribution, so that if I write a book, it can be known that it was written by Sharon Water. And Helen Ambassa, for example, cannot come and put her name on my book, yeah? Because she liked it so much and she read it and she used it to teach people. She decides I can put my name? No. So that's the right to attribution. It is not transferable. Even when I die, nobody can inherit it. You cannot transfer it. I also have the right to have the work published anonymously or pseudonymously. In the past, there is a period I know that, for example, women could not write books, and some of them had to write under men's names. If you think about the book, I think it was Out of Africa, and the movie, if you guys have watched it, the lady Karen Blixen was an author, but in that period, she could not write as Karen because she was a woman, and then she had to use a man's name to write, but yet this was her work. So again, copyright gives you that right to publish in that way if there's an issue. It also gives you the right to the integrity of the work, to preserve it as you want it to be. For example, when I sing my nice gospel song, you don't want it put in a pornographic video, because then you know it is going to speak to your reputation and who you are. And so copyright gives me that right to object to that. So that is what we call moral rights. Then you have economic rights. Economic rights is what I was mentioning before. I need to control who can reproduce my work, so that if I have a book out there, you cannot pick the book, go and reproduce it in many copies and begin to sell it without my permission. I control that. So for example, if I have contracted a publisher to do that, then I know this publisher is the one who has the right to do this with my book. So not every publisher out there can pick it and reproduce it. You have the right to, you control the right to adapt and translate your work. Again, if I write if I sing my song in Luya, When you want to put it in Kikuyu, you have to ask me. I reserve that right to accept or not accept. The right to distribute publicly. You can distribute by sale, rent, hire, lease, all those actions, what is considered distribution, importing, exporting. So I have the right again to control that action, who does it, the right to broadcast the work, communicate it to the public, or perform it in public. Again, if I'm going to do a public performance of somebody's songs, I would need to get the permissions required from the person. The owner, the copyright owner, reserves that right. They have to agree who can do this, who cannot do this. Again, I have said moral rights are not transferable, but economic rights can be. You can license your copyright to somebody, you can sell it completely. When you die, somebody can inherit it, whoever inherits your estate, so that if there are any proceeds or royalties that you're getting out of your work, then these people continue to get that money. Because remember, copyright, the term of copyright lasts usually for your whole lifetime if you are the creator, and then 50 years after you die. So if I sing a song today, copyright will subsist in that song until I die. So if I die when I'm 100, that means 50 years after that, the copyright still subsists. Once the 50 years have lapsed, we say that the work has now moved into public domain. So then anybody can use them without the permission or without paying for them. And that's why for those who listen to music, gospel music, you will hear people sing a lot of hymns, because hymns are very old, copyright has lapsed, and they have now moved into the public domain. I don't know, maybe I should stop there, Helen, and then let Liz do a bit of entertainment law, and then we'll come back probably just to delve into any questions that may be arising, or if you have specific questions that you would want us to address, then we can continue with that.
Okay, I see a question about hymns sung in churches, and I think you've answered that. So
okay,
we'll move to Liz and then come back to...
Sorry, Helen, I can clarify that also further.
Okay.
Hymns, the copyright already expired because the people who wrote them and came up with them died a long time ago. The years have moved, yeah? So right now, I can sing a hymn in my style. I can sing in, let's say, Benga. You sing the same hymn in reggae. So again, there's something in copyright we call expression. What is it called? The dichotomy thing. Oh, sorry, I've forgotten, but we'll come back to it. Idea, expression, dichotomy. The whole idea is that copyright is not protecting your idea. I get a lot of questions, and a lot of people come to the office and say, oh, I have this nanny idea I want to protect. No, copyright protects the expression of that idea. Because usually with artistic things, we say that if I do a painting, I put myself in the painting. If you know me, Helen, you will look at that painting and say, that looks like Sharon. If I write a story, if I tell a story, you can listen to it, you can read it and say, yes, that sounds like the person I know, because you put part of yourself into it. So the way you express it and the way, for example, Liz will express it are different. That is what copyright protects, your expression of that thing. So the reason that hymns are now into the public domain, if anyone is allowed to sing them, everyone is allowed to sing them, you can sing them word for word. What copyright is going to protect is your expression of that idea.
So this question is from someone in the beauty industry. So if I'm an expert in, let's say, eyebrow shading, microblading, the expression, me actually, that artistic expression of doing the eyebrows, do I own that? Or can I, for instance, use you as a model and then claim that that's my copyright, no one else can circulate that?
No, you know, with copyright, it's like we all build on ideas and get inspired by ideas we see around. So you cannot say, this is my idea, I'm the one who came up with the idea of carving eyebrows looking, I don't know which side, so I've copyrighted that. Nobody can do that. No. Number one, you may find out you're not the only genius. There are very many people with the same ideas. So what we are going to concentrate on if you want to register something or protect something is exactly what you have done. Yeah, so if that person picks exactly what you have done and does it, which is very difficult, you and I can decide to draw an apple.
Mm-hmm.
You cannot say I've copyrighted the idea of apple drawing. Nobody can ever draw an apple in this life. That's very ridiculous. It doesn't work that way. But if you draw your apple, the way you shade it, the way you draw it, the angle you look at it from, that's what copyright is protecting. Your expression of it, how you have viewed it, how you have translated it into that material form. I forgot to mention that copyright, you need to reduce, for you to get copyright in a work, you need to reduce it into a material form. So if it is a song, for example, you need to sing it and produce it. If it's a book, you need to write it. It needs to move from your head into some material form that people can see and touch. That's what they call fixation. That's what the law calls fixation. You have fixed it into a CD, into a book, into whatever. So it's usually unreasonable, so to speak, to claim copyright over ideas you have, which you have also built on other people's ideas. I once had a case where someone said they went to the rooftop, I think, of KICC and took a photo of Nairobi. And so they think that nobody else can ever do that because I did that. You're not the first one to do that. You're not the last one. Anybody can. What the court would be looking at is the exact similarity in this work to say that this is the same person who did the work, you know. But if it's different people, there are different techniques, especially like now with photography. People use different techniques of expression, different, I don't know, there's something people do, play around with light and shade and whatever. And so you can see, like, we have taken the same scenery, the same photograph of the same scenery, but it comes out different based on how you know how to do your thing. It may look similar, it may not, but the idea is you're only able to protect yours, that thing you have done as Helen, and not the idea that nobody can ever do this.
Okay.
Yeah.
Thank you. Liz, over to you.
All right, thanks. So hi, everyone. We're happy that you've joined in and welcome to our session. I'm sure we'll have an amazing interaction and we look forward to your questions. So I think I'll start with what is entertainment law, because guys always wonder, what does entertainment law really mean? If for those who had attended the previous webinar, I believe you were introduced to patents, trademarks, industrial designs, and all, you know, what the intellectual property law of body of law looks like, right? So entertainment law is a culmination or a combination of now all these legal strategies, from protection of the expression of ideas and the protection of all these intellectual property assets that are created, and harnessing, you know, issues of contract law, employment law, issues of, you know, how do you handle your marketing, your distribution. So that's what entertainment law generally would envision. So I'm an entertainer. Let's say I am a script writer, right? So what you need to do, or you need to realize what entertainment law does for you is, where do you start? And as Sharon aptly put it, you start with copyright, the expression of the idea, you fixate it, and then you protect it. So how do you protect it? Now we have registration of copyright, where you register through the Kenya Copyright Board, and they assist you to, confirm that you are the author or the writer. And this generates from a system where in the older days, where, you know, people would actually write their scripts and mail them to themselves before they, you know, start commercialization, because they were like, oh my gosh, how do I, confirm to members of the public that this generated or was created by myself? And then eventually, the different countries came together and said, you know what, we shall introduce an element of registration. It's not compulsory, but it's prudent. And as you've seen, it protects the expression of ideas. We are all geniuses. We are all exposed to the same kind of subject matter and all this stuff. So how do you then ascertain that you are the author of a particular work? So you register it, because that's how you, sort of protect yourself. And copyright is very fluid, as you see, expression of ideas. So you start there as an entertainer or in an entertainment business, because entertainment is very copyright heavy, expression of artistic and literary works. Now, something that also needs to be very clear is that copyright does not protect business models or techniques, right? So it's about the expression of ideas, which is very important, because there are people who come and say, oh, I came up with this idea or this technique, so I think, I own something and no one can copy me. No, but it's the expression, and then how the kind of other legal strategies you would use to protect what you're trying to create. So we've come up with a script, we register it under copyright. Entertainment is very heavy on networking, right? So how do I proceed? I do not have perhaps access to financing. How do I then move to the next level to, put my work out there? So you have the option of either I want to work with a broadcaster or I want to work with a private film producer. Contracts are very important. If you decided to go, through the broadcasting mechanism, it's very important. How do you share your work? You see, you are sharing your work to someone whose entertainment and scripts and film is the ordinary course of business, right? So because copyright protects the expression of this, of the idea that you have created, you have to be very smart with how you share your work. So please don't share it on email, right? I'm sure we've seen in the past years, we've had Kenyans sharing their scripts through emails or WhatsApps or whatever. And then the next thing you hear, oh, broadcaster X has infringed on my copyright. They took over my work, yada, yada, yada. You see, if you do not follow the right mechanisms, because copyright protects the expression of an idea, how do you prove that you brought a particular expression to this broadcaster who is, this is the ordinary business, right? They have employed in the thousands, people who could come up with similar creations, right? So under common law, we have the mechanism where we now help you package, as a lawyer would help you package this work as a confidential, confidential information or products, right? So that then you're saying, I am disclosing this information that will revolutionize your business, but you have to sign a contract to confirm that I am the owner and that should you use it to my detriment, you will compensate me, right? So that is one of the things we do not see a lot of people in entertainment, trying to utilize. Now, with entertainment business and entertainment law, we're talking about intellectual property mechanisms coexist. So, I have a fabulous film. How do I make it bigger, right? So there's a copyright aspect. I come up with a name, I need to register a trademark because it protects. It gives me that exclusive use over this name that I have given, or my product. So for example, Game of Thrones, right? And as I'm registering a trademark, I'm looking at the big scope. What else do I want to do with this creation, right? You look at Harry Potter, what they did, they went into merchandising and all that stuff. So you declare your issues, your areas of business of interest when you're registering a trademark, so that then you're not, passed by opportunities, and the law will protect those who are vigilant, right? So if you say, for example, I'll give a very interesting case that happened a few years ago. When iPhone launched in China, they registered their trademark under just, creating of mobile gadgets, right? And then some guy says, oh, wow, these phones are actually pretty awesome, but they're very delicate. I need, maybe I can start a business of creating phone covers. So the guy went and registered an iPhone and the iPhone trademark in the goods of leather goods in the section, or rather classification of leather goods. So he's creating some nice little covers, nini. Then iPhone takes this guy to court and says, but this guy has infringed on our trademark. And the court asks them why or how, because you guys are only declared in one class, right? So it's very important that you are very wholesome and futuristic in terms of how you want to handle your entertainment business when you're creating some of these assets. You hire a designer, an interior designer to create a set for you, for your film or for your show. It's something that can be protected. We're talking about industrial designs, all these elements that can be put together. So figuring out also as well, have you been, commissioned for this particular work? How do you handle that intellectual property, all those intellectual property issues in that space? Contracts are very important. And when we're talking about contracts, I've talked about NDA, which is amongst the first pieces of contracts that you need to have in place. Then all these crew that you engage with, or what kind of contracts are you having? You have hired a director. Are you going to share in the copyright of the audiovisual work? So it's very important that you understand the scope. If it's music, you're going to write a song, you need a split sheet in place to begin with. You have sort of had the reruns before you record. On who owns what, whose contribution to the song, what does it look like, the preliminary stage. By the time you're recording, you already have had a conversation with the producer about, are we paying you for studio time, or are we paying you to own the master recording? If we are paying you to own the master recording, let's have it in writing. Entertainment needs to embrace a lot of formality. Our challenge right now is that we do not embrace formality. We are afraid of lawyers. I don't know why. And yet you need lawyers in the ecosystem to help you, protect your intellectual property. And I think when you look at Hollywood, when you look at Disney and how they have harnessed all this synergy, it's why they are an entertainment empire to reckon with. And I think Kenyans and Africans can get to that level. So we really need to, move away from that gentleman agreement strategy of dealing in the business. You're like, oh, no, you're my friend, let's do this together, I'll hook you up when we make money. No, have it in writing from the beginning. Even when you have nothing, have it in writing. You can always amend a contract. And then in entertainment, we're talking also about issues of how other laws come in place or into play with how your business can be, fortified, quote unquote. So we're talking about issues of, what licensing mechanisms are there for your production. Are you aware of them? So if you need, you need a license to go and shoot in a certain place, you need to acquire the license. Here we are talking about Kenya Film Classification Board. They have to review your script and look through that. And then after that, it has to be classified. The issues of, if you're going to shoot at someone's premises, you need to clear certain rights. The models that you're going to use, the actors and all these people, they all, there are certain rights that you have to clear. So we're talking about image rights, for example. Same thing would be if, you decided to do a movie, for example, of the late Nobel laureate Wangari Maathai, you need to clear those rights. So that whole system is what we're talking about when we're talking about entertainment law. Distribution of your work, how are you distributing it? What are some of these commercial opportunities that are being brought to you? What do they mean for you? You need to understand the business scope, the current trends as well in the entertainment business, depending on where you are, film, music, publishing. You need to be very aware of what's happening so that then you negotiate a good deal for yourself. At the same time, we need to also start figuring out as Africans and as Kenyans, how do we market ourselves? So, there are other mechanisms like the Creative Commons license that now has been in existence for a while, where we need more Africans to start putting together and donating some of their work to this cause, so that then you're also recognized. Because have you ever asked yourself why some of these Hollywood films will shoot something that is inspired by the Kenyan culture, the Kenyan culture or South African or whatever, and then they get a foreign artist to score for the film? It's because they don't know us, right? So I mean, we need to move from that place where we are stuck with mine, and figure out how we're also going to create and shape the body of common knowledge. So I think that's a good introduction to what entertainment law is and how we can sort of get to the next level.
Yes, thank you very much, Liz. A couple of questions have come up in reference to what you just said. I know you talked about entertainment, needing to embrace formality, and posed the question as to why do we fear lawyers? Do you think it could be perhaps because in terms of remuneration, we think the lawyer will take all the money?
True, and it's a very common misconception that I've even seen with some of my clients. And I ask them, would you rather fight for 100 shillings by yourself, or work with an expert or someone who can assist you, and you get 100,000 and you share it, which means you get more than the 100 shillings that you are anticipating. You probably make 80,000 and you're going to just share 20,000 with Liz, right? So it's about looking at that scope. And I think that's what artists and creatives need to really realize. And the other thing is they need to be aware that lawyers are also humans, right? So we are not like closed into the fact that, you know, you have a family, you're broke, you are in debt. Like, it's all about disclosure. Ask and ye shall receive, you know, like come up and negotiate, because business is about negotiation. It's not about or trying to fly solo and then you find yourself in this very messy situation, and then what, right? And all of us here can attest, a lawyer is more affordable when we're talking about protective lawyering than defensive lawyering. So I think they always need to remember that when we are fighting a case, of course, we will slap you with a huge bill because your stress becomes my stress. But when you're protecting you, it's so much easier. It's something I can do with my eyes closed and we are happy. So, yeah.
Okay. Yeah. Now, there's a question here. There are a couple of questions, actually. So I want to gauge, so from the two of you, do we take these 15 questions first, then we move to the next segment? I think it will be easier to manage that way, as opposed to now getting into another presentation when we've not addressed some of the issues that are arising. So the first question is the one Sharon answered. What happens to hymns sung in churches? I think she articulated that very well. There's a question from Nyanchama Ataya. Is it illegal to make a website that has different links for YouTube videos that, for YouTube videos that aren't yours? And there's a note there that people who click the links increase the viewership of the specific YouTubers. So you want to take that question first?
Yeah, the issue of linking is not right without permission. You need to get the permission of the owner. I know the argument is usually, I am promoting this person. And I'm tying it to another question I saw somewhere, someone talking about playing music, that if you do the enforcement vigilantly, you're going to deny the people. I think it was Dr. Kobudi. You're going to deny the people exposure they need, yeah? There's an angle of exposure to it, yes, but there's also an angle of infringement. The whole idea is that only the owner should control reproduction, communication to the public, performance to the public, and all that, yeah? And so without that permission from the owner, then that is infringement, and especially where you're gaining commercially from it. Yeah? So like this website person, how do they gain from putting these links on their website? Are they gaining themselves commercially out of it? Ingawa, they're saying, I am also promoting these other people. So it's like, it's a catch-22 situation where you have had cases where this mama was caught stealing bread and milk from a supermarket because her children are hungry. We all will understand that and be like, she was desperate, she is hungry. And probably if she went before a judge, they would just be like, okay, yeah, pay 100 shillings and leave, you see. But it will still be a crime. Whereas you understand the reasons and why it was done, it is still not the right thing to do. And one of the things I've realized with most of us Kenyans, we don't ask for permission yet. Sometimes it's just easy to get.
Yes.
If you come and tell me, I want to put your song, to link people to your songs on YouTube on my website, and it's going to promote you and it's going to whatever, most likely I'll say yes, especially if I don't have to pay for it and you're actually just helping me to do this. Most likely I will say yes. But with most people, they will skip that permission getting. But now if a problem arises, because some people may think, now that you put my song on your website, it has promoted your website and you have received a lot of money share, then the problem comes in, you get? So I think the law is that you need to seek the permission. Sometimes the permission is not, it's not hard to seek. And sometimes it's easy to convince people to do that with their works and they will agree. Liz talked about negotiating in terms of business. Eh? Any business, it's about talking, negotiating, coming to an agreement. And so I think the right thing is always to ask. I also saw another question about someone talking about using clips from a film for educational purposes. I think most people will say it's educational purposes. Okay. So copyright has exceptions and limitations, but they all have to be within the law again. So the Act will allow you to use copyright protected material in certain circumstances. For example, they say for critiquing, for news, something like that, for educational purposes. But even for that educational purposes, it needs to be within the law. There's always a tripartite test that is done under the Berne Convention. Is your use going to jeopardize the interest of the owner? Is it going to prejudice the interest of the owner? Are you using substantial material to that effect? You know, so all these things have to come to play when you're using the educational purposes reason. You have to weigh, but you must always acknowledge that one. You must always acknowledge that this thing is from this source. So acknowledgement must always be there, but also, am I gaining commercially by using this? That's another test that you can always do if you want to find out, am I now moving to the realm of infringement or not? When I'm using this thing, how am I gaining commercially? And if I'm gaining commercially, am I ready to share that gain with the owner? That's the fundamental question here. And if I am using this thing to gain commercially, is it taking away something from the owner, something that the owner could have gotten? You understand? I'll give you a simple thing like photocopying of books. In most of our universities, that's a normal. When I did law at University of Nairobi, the books were expensive. You'd go look for a textbook, it's like 5,000. I mean, 5,000 is your rent. You're not going to buy a book for 5,000. So there's a guy who had a photocopier and he'll just copy whole books, sell it to you at 500. Guess which one I'll buy? The 500 photocopied book, right? What does that mean? That means that less books are going to be sold. So the owner and the publisher and the author are going to get less money. So that means I have taken from the publisher, I have taken from the author, which is not a good thing. But the person I have enriched is the copier guy.
Yes.
He's making the money. Yeah, he's making the money. It's not his book, he's not the author, he's not the publisher, but he's making the money. So, you know, you have to put all these things into place. Sometimes I know we say that it's for a good cause, it's for a good cause, it's for a good cause. I'm promoting the musician, I'm promoting the author by using their work or putting it out there. That reserve, the law gives that reserve to the owner. You can think you're promoting me by playing my song in pubs. There's a popular song, gospel song that people love to play in pubs. I heard Kuna Dawa. And the drunk people will be like, Kuna Dawa, Kuna Dawa. In their mind, Dawa is what? Whiskey or whatever, or beer. If you think about it, the person who did that song, was that her intention? Was that her meaning? No. So you're infringing on her moral rights to do with that song, because you have turned around the meaning of the song. You're using it in a way she didn't want. She wanted to use it for gospel purposes, for advancing the gospel or whatever. You're using it for other purposes. You have changed it, yeah? So you are already infringing on their rights. You may say, people have come to know Kuna Dawa, and you never know. People might get saved out of it. You don't know. Maybe, maybe not. But at the end of the day, it's not the end that would justify the means. We need to just do what is right. I had also seen another question. Helen, I'm actually able to see some questions on the chat.
Yeah, I just want to interject a little bit there and ask a question in relation to, I've seen a lot of people, basically, when a new book comes out, like this latest expose, this Tell It All by John Bolton. It's being circulated via WhatsApp, you know, PDF. You know, could you speak to that also? Because my view, it's also a violation of his rights as an author. What will he gain by you circulating this book and is not getting any monetary value when you circulate it from group to group?
Yeah. Sure, that sharing is always an infringement, a violation. But then the other problem is where it originated from, yeah? Like if you make something that is capable of being shared online, and then now it's out of your realm of control, then you also need to take responsibility. You know, copyright is a private right, yeah. We take it as a property right, yeah. That's what it's called, intellectual property. So it's the same as you can own a car, you can own a shamba. So if I decide, Helen, to drive my car into town today and leave it there with the key inside and the windows down, I'll find it in Namanga or whatever, or I won't find it. I had a neighbor who once went to Kenyatta Hospital to visit someone, and she parked and went to see someone, and she came back, the car was gone. And she was so confused. She was even looking for it in her handbag, like, where did I keep this car? You know, you're so confused, you know. Although she had locked her car and everything, but now imagine if you parked your car in a place where it is very accessible to people, you left the key inside. In the US and whatever, people don't even lock their cars, right? But nobody will come and pick it, yeah? But here, if you took it in the middle of town and did that, somebody will definitely pick it. So you will now begin at, okay, let me go and report to the police station. It's the same thing with copyright. It is your right, it's your property. So you begin with you at guarding it. If I want to share my thing on Facebook, if I want to share my thing over the net, have I put the safeguards that are there? Because I've seen so many books, you will be doing research and reading and come across this really nice material and try to download it. It only gives you a page. And then when you try to download it, it takes you to another place where you need to pay. Yeah. So there are digital rights management features that you can put on your work that has gone online. But maybe with that one also, the other thing to know is, again, is it for private use? You know, sometimes people just share, I see something nice, I say, let me send Helen to read. For private use, okay, that's okay. But then by the time you find someone telling you, pay something, I forward you this book, or they're selling, some people end up selling. So the one, again, for commercial use is an issue.
Yeah, you talked about digital rights. So perhaps now would be a good time for me to pose to you this question from the last webinar we held on intellectual property rights. There was a question about what ways exist to protect creations online, e.g. on YouTube or social media. So the example given was hosting a program on YouTube, then a major media channel copies it, and whether this individual can actually challenge the media channel's action to copy what they had on YouTube.
Yeah, sure, they can, but then they would need to follow the YouTube. YouTube have a copyright policy, so you would have to follow their policies. I know with YouTube, if there's anything infringing on your right, you can always, I think you send in a complaint and you ask them to take it down. Right now, with the amendments that we did in our act, we basically the provision is that any ISP, internet service provider, you can ask them, you can give them a takedown notice and ask them to take down any material that is infringing on your copyright. And they are bound to do that. You may not hold them liable, especially if it was not initiated by them, but since they're the service provider, you can ask them that this is infringing on my whatever, take it down. So I know, like YouTube, they have a policy, a copyright policy, whereby I think there's a link, there's a place you can go and complain. Their first reaction is always to pull down that thing first and then begin to find out what is happening. So with most platforms, they would always have a complaint policy. I think Amazon also have. They would always have a policy on the issue of complaints. But no, when we get to the realm of online, it is very difficult to monitor because it is easy to reproduce something in a matter of seconds and spread it wide, you know. When I was talking about people taking care of their property, someone was asking here that there should be an institution in place to monitor copyright issues. Yeah, it is. And the institution is the copyright board, but it is not our work to monitor, responsibility to monitor each individual's work. It is not even possible. You may need a workforce of 1 million people in Kenya to do such kind of work, yeah? So we would have to wait for a complaint from you as Helen to come and say, somebody is infringing on my work. Then now we do the enforcement part, yeah? Same, in Kenya, stealing is a crime, isn't it? Murder is a crime. But do those things happen? They do. But the police are there. So once something has up, something of yours is stolen, then you will go to the police. But you can't say that the police need to be stationed in every home and in every place on the street to check what is happening, which is the same thing. Copyright is a private right. It is a private right to personal property, even though it is intellectual property. So the bigger burden of taking care of this is on you as a creator. And then when there's an issue arises, then you have enforcement now from the government, which you can always work on.
Okay. Sharon, I have a question, given what you just said. There's this YouTuber, he's called Rajveer Soin. He goes by Adventure Sing on YouTube, and he has really great visuals. And I think it was a few weeks ago, Citizen TV just took a clip from his, or allegedly took a clip from his YouTube video and used it in their kind of reel for, I think it was Madaraka Day or something. And of course, he's the rights holder, and he approached them and they ended up negotiating compensation for that. So my question is there room for collaboration between a rights holder and an infringer? And how would a rights holder navigate that interaction? Because sometimes consent is a luxury. Sometimes you just find someone has used your creative work, and yes, you know, you can maybe follow it up, but sometimes it can end up being very nasty.
I think for a rights holder, your goal is not as much as to punish, but to reap from this work of yours as much as possible. So I think I think it was a good idea to have a negotiation and you know, come to an agreement of payment, because what would the other option be? The person has already infringed on your work is already out there. So what is the remedy? You can have an injunction to stop them, fine. But what have you gained out of it? And I think for artists, the bigger issue is, how much more can I gain from this? So you might even actually talk to someone and end up deciding, okay, let me license this whole copyright to you. Let me sell it to you, Basi, you can have it. Let me sell it. Let me license it. Let me do something. Because at the end of the day, you're more concerned with, how do I gain economically as much as I can from this? But besides that, if you're an artist, you also know I can always create something else. I have the talent, I have the capacity.
Yeah,
I can always create it, isn't it, Liz?
Yeah.
Yeah, you always know I can do something else. Liz, would you want to make a comment on any of these issues?
Yes. So in terms of issues of linking, especially in the internet space, I think it's not entirely always copyright infringement, unless there's what we call circumvention in the digital space. And what is circumvention? I'm sure you guys have been hearing about how the media houses have been complaining how the newspapers have been circulating and whatnot. So let me explain. I have on my Facebook page, I have seen, I don't know, Nonini's song. I think it's awesome. It's a TBT or whatever, right? I take that song and I copy paste it on my Facebook platform. I have shared it, right? That's linking, right? But now the question in law is, have I infringed? No, I have not, because I have not introduced a new audience. When someone clicks on this link, it will take them back to YouTube on Nonini's channel. They will watch the song. He'll get his compensation, whatever, right? So when, you know, linking becomes an offense when you introduce what you call a new audience, that you have circumvented some digital rights management mechanism, and then now you have made, you know, people, you have given access, unauthorized access to someone's content, right? So that is when it becomes an issue. So even for bloggers, hyperlinking is okay as long as, you know, it's content that you have not introduced a new audience, you've not broken any sort of digital measures to introduce, right? So I thought that is always something that people need to be aware of. So, you know, and some of these platforms, what they've done is they have a subscription model. So the minute, you know, people who do not have subscription can access this platform, then that is copyright infringement in the digital space. So it's very important. At the same time, when you're putting your work online, it's very important that you read all these terms and conditions of the platform.
Yes,
so you put your work on YouTube. Have you read the YouTube terms and conditions? What does that mean for your work, right? You need to be very aware. As Sharon said as well, you need to take responsibility for the actions you make with your work. The thing is, you know, once you've put your work out there, you've created like some sort of body of idea as well. So someone else will create something, but that borrows from the inspiration, of what you've created. So then you cannot really stop a media house from creating another soap opera of Antonio and I don't know who, having an affair, yada, 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 And it's important for creatives to always realize that. So, if you have something that is a very interesting or unique expression of an idea, you have to be very deliberate with how also you share it and how you will monetize it. How do you become fast to monetize it before anyone else, because some things cannot entirely sort of be protected. Yeah, that's what I wanted to add.
Yeah, so there's a question here. I think Liz, you take this one.
Mm-hmm.
Hi, I'm a cinematographer. Does copyright apply when part of my work is reproduced as a meme?
It does. The challenge is enforcement. I think for us in Kenya and even Africa, we've not yet moved to that step of figuring out how we'll handle it. But the EU is already, I think they've even passed that directive to figure out, to sort of legislate around the memes. So I think, like I said, again, how can you make some of these difficult exploitation mechanisms to be a win for your business, right? You could be the person to make that meme for yourself and figure out how does it then, how do I gain, how does my film or my cinema sort of, triplicate in its monetization, or how do I then get noticed to have created? Because there's some things in the digital space that will be difficult, and it's very social, right? People today wake up and they're like, oh my gosh, someone came up with memes. Tomorrow someone else will come up with something else. It's just about figuring out how to also be dynamic and take an opportunity, something new, and make it an opportunity for yourself. So memes, for now, yes, it is infringement in the plain sense of copyright law, but now it's going to be difficult. Like, how many of us have memes on our phones right now? Can you imagine? It's going to be difficult. So it's just about now being creative with our business models to get into the next level with our creativity.
Okay. Does any of you want to take us through, if I do a cover version of a song, because Sharon talked about the rights holder's goal not being to punish, but to reap as much as possible.
Yes.
From the infringement. So would you classify a cover version as an infringement, and how could you just take us through that? Okay.
So I'll take that. So I create a cover version. Is it mine entirely? No. I have used someone's work, and I've done a rendition, a Kiswahili rendition, for example. And I will use an example of what's her name? Hello by Adele, right? Remember how that song was huge, right? Now it's important to realize that, yes, some of the songs, some of the renditions and versions and covers that were put online were not flagged off. Ask yourself why. It's because the rights holder, through her record label and her publishers, ensured that there was digital mechanisms by YouTube and all these other digital platforms to ensure that they can still sing her song, but on the back end, Adele and her people were making their money, right? But there will be instances where it will automatically be pulled down, let's say, for example, on YouTube, because the author has the right to refuse and say, I do not want you to use my song. So when you're talking about cover songs, again, as Sharon said, it's prudent that you ask the author, the owner, on whether you can use. And then with the goodness with having that concept is now you can negotiate on the figures, right? Yeah. So I've decided I'm going to do a reggaeton version of this song, and I'm telling them, you know what, I'm a reggae artist. My artists love reggae. I have a following of 100,000 guys, and I'm investing now. I'm creating a new sound recording. So how about I pay you 20% and I keep 80%? Have a conversation about that. The good thing with permission, then you get to rightfully gain. When there's no permission, then you tend to lose out. Even the initial investment that you put in to recreate becomes, a waste. So with derivative works, you always have to get the permission of the author because your plan is to gain, right, on the work. So cover versions are not free. People imagine that, you know, I have a production, I play 8 seconds or 10 seconds of a song, and it's free. It's not free. It's someone else's work you need to clear. It's the same thing as, you know, having a farm. If I pass by your farm and I pick a tomato, I have stolen. I can't say I just passed by and I saw a ripe tomato and I just picked it. I didn't steal. I've left you with 50 tomatoes. I have stolen, period, right? So it's important. With cover songs, always clear the rights, and then, you know, negotiate some sort of you know, split of royalties on the new piece of work. Because yes, you can create a new piece of work, but the minute you start to commercialize it, it becomes infringement. It's the same thing even with patents. If I have an existing patent and then I create an improvement to the patent, but the patent is still valid, there is no way I will monetize without clearing and getting a license from the initial patent holder to monetize. So it's the same thing with music.
Okay, thank you, Liz. Sharon, do you want to comment about, you know, during this COVID season, we've had DJs entertaining us every Saturday, and you guys were about to throw a spanner in the works. You want to talk about that?
Well, I want to say something short so that we don't start a whole debate that will take us to 5 p.m. The whole idea, Liz and I have alluded to this, is that when you're using work for commercial gain without permission, the general rule is that that is infringement. So now you need to look at it from, and with this one, I want to sound vague because there are those who have said that a DJ's work is an original work of its own. The way he mixes, the way he does whatever, it is also an original work. Yeah? But the questions you're asking yourself also, does he interfere with the original work in the way he mixes? Because most of the works I have heard from DJs is like, this song has a t-shirt, they've put another one. Then they put another one, then they put another. So you're mixing it up and you're cutting off some songs. Is that alteration? Is that altering someone's song? Is that, you know, altering someone's original work? Then some of them don't do work for, okay, well, during this COVID season, I don't know if they were doing all these things for free, but most of them, again, don't do entertainment for free. They do it commercially, yeah? Again, are you gaining commercially from this work? And so with the general rule, let's say that the copyright general rule is that if you're going to use somebody's work for whatever reason, and you're going to gain economically from it, then you need to pay for it. Okay, for DJs who have like a premise where they go to and they're paid for it, and the premise has already paid for the copyright license, at least those ones are covered. But the one who does their own gigs, their own whatever, I think, Liz, if I'm not wrong, there has always been a tariff in the tariff, yeah?
There's a tariff for a roving DJ.
Tariff, yes.
Yeah, they're called
roving DJs. They are called, exactly, yeah. So they always need to pay for it. But for me, I think what I want us to take home is that whatever you're using without permission, does it interfere with the original work? Question one. Question two, are you gaining commercially from it? If you are, is it something you would be willing to share with the owner, the original owner, or not? So those are the three fundamental things you should be asking yourself with anything to do with copyright. Am I using it for commercial gain? Am I interfering with the original work in terms of distorting it, whatever, changing it, adapting it, translating it, whatever. And am I taking something away from the owner of the work? So I think if we always ask yourself that, then it's easy to know whether you are moving into infringement, which is theft, basically, or again, you're just playing within the safe place. There was a whole statement done on this from our office, which, because today I don't want to be here in that capacity, but I think it is, you can find it in on our Facebook page, our Twitter handle and whatever. There was a whole statement from our office around the issue on DJ mixes and all, yeah.
Yeah, the concern, I think, was around the amount that was being charged. And there's actually a question from Marcelina.
Well, the thing with amounts, with the tariffs, is that these are negotiated tariffs. You don't just, the CMOs don't just wake up and do a tariff. They need to propose a tariff. They bring it to copyright board. We have engagement with stakeholders. Like, for example, with hotels and restaurants and whatever, there's always that engagement, yeah? Matatu owners, whatever, and say, this is the proposed tariff. What do you guys think? Then people give their view. So by the end of it, when you're coming to an agreed tariff, there has been a process. And the process has to involve engagement with stakeholders. And then, of course, there are moments where people have felt probably it's not working for them or whatever, they have gone to court. And Liz knows that they have gone to court, they've gone to the tribunal if they have an issue with the tariff that has been agreed upon. But the tariff is always a process. It's a result of a process. The process is propose the tariffs, okay, come, we question you. How do you propose this? How do you propose this? Meet these people, they tell you, come on, we don't even make this in a month. How do you want us to pay this? So you go through that whole process before you agree on a tariff. Then the tariffs are now gazetted. And now once they are gazetted, then those are the operational tariffs.
Okay.
Yeah.
Thank you. Salome and Susan, you have a couple of questions, particularly Salome. There were 2 questions that had come before.
So,
is she there?
Her mic is off.
I'll allow Susan to take the questions.
The 2 questions that you had from, was it yesterday?
Susan can go ahead as I retrieve them.
Okay, all right. Susan.
Helen, you were at the chat box. Shall I go ahead with the questions on the Q&A? Because I see there's still the 2 sets of questions in the Q&A and the chat box.
Oh, okay.
So let me just.
So there's, oh yeah, okay, that's the confusion, yes. Yeah, go right ahead, Susan.
Okay, so there's a question from Wamushi Kabue. How do we balance the rights of copyright owners and related rights, and in particular with regard to remuneration, taking into consideration related rights holders, or is it merely contractual?
Okay, I'll take that. And I know with related rights, there's it's predominantly with music, because music we have the copyright holder, and then we have the performers and the producers, who are the sound recording right holders. So I think one of the things, it's 2-part, right? There is the issue of performance in public places, where it's important that CMOs represent the different rights holders. So the related rights holders as well need to declare themselves in the respective CMOs. Now, the declaration is not mandatory, but it's recommended and it's prudent, because you're basically going to, camp, Kenya Association of Music Producers, and saying, hi, I'm Musiox, I own Decimal Records, and I am the producer on song X, right? And then someone else comes and says, hi, my name is Karun, and I am the singer in this particular what? I am here to register at Performance Rights Society of Kenya, so that then now when the song plays and they get some money, they'll be able to say, okay, for the related rights, here is your money, Karun, here is your money, Musiox, like that. So in the public domain, in public performance, that's how it's handled. In the digital space, it's why, again, I said in earlier, contracts are important, because now, we have platforms that, are facilitating the distribution of these works. So now contracts need to be envisioned, where now we are saying, okay, we have created this work. If you put it on SoundCloud, if you put it on iTunes, if you put it on what, how do we, share this money together as co-rights holders in the different system, in the copyright and related rights sort of whatever. So when we don't see that happening with our artists, right? And because that hasn't been happening as well, now the CMOs are coming in to assist. So we've seen Camp and Chris also now having conversations with some of these platforms and saying, hey, we need you to take out a license, so that then we can, compensate the related rights holders, because also they don't have that information. They have not realized that they have that, sort of right to gain from, these downloads and all that stuff. So I mean, contracts now are becoming a very important thing in terms of figuring out how to get compensated on the related rights. The same thing even with film as well. You know, it's important about having that discussion. What role are you playing? Then as the executive producer also, I have to be very honest and say, you know what, it's impractical to have 20 people having rights, right? I'm paying 20 people royalties. So then I figure out who did I bring on board for a work for hire arrangement, make sure they understand that they're here as a work for hire. They are paid for their service and they move on. They don't start saying, oh, but that film has made a lot of money. I think that, you know, the way I held the camera, now I have copyright over that shot, you know, like things like that become very unrealistic. So, you know, with the film space as well, it's very important. If I bring in a director who has such a huge reputation and I can't afford, and then maybe we're talking about some sort of copyright share in the audiovisual works. And, figure out how to you know, make money. You know, what we're seeing also, like in Hollywood, I think we watched the film Wakanda. Black Panther, right? Some artists, because of how huge they are, some of the actors like Peter, them, they were able to say, you know what, I believe in this vision, we don't know where we'll go. So for me, because me I earn premium, I want 5% or 0.2% of, you know, whatever, of the royalties. And it's fine. And then there are those guys who are just paying and they're told, thanks, just, you know, I served tea in the film. Do I need to ask for royalties, right? So everything.
And would you say there's an aspect also of like civic awareness? Because in an example of a background singer or background vocalist, they of course have related rights, but they might not be in the parameters of maybe knowing that, oh, when I did this, I'm, you know, our rights accrue. So in that context, civic awareness is also good, and CAMP and all these bodies do have the mandate or take the initiative to make sure the information is going out there and having these workshops, because it's also about localizing the information so that I know, you know, when I'm in the house and I'm doing a cover, or I'm, you know, going to this artist and I'm going to do background vocals, there is something that arises from that. I'm not just, you know, being
Yeah, and there are a number of trainings that always happen. The challenge we have seen as one of the facilitators is that people don't show up, or people who register and they don't come, and they don't realize that actually there was information for me to be aware of. Because it's true, there's so many background vocalists who have no idea, right? There's been a confusion between who is a producer and who is a track producer in the music space. Because a track producer is essentially a performer. What he does is just, he has that fancy machine in the studio and he can just press a button and play a guitar, right? And he's not the guy playing the guitar, right? So, you know, things like that, you know, people have not, you know, sort of gotten information to understand, then understand also how these CMOs can help them and whatnot.
As you are talking royalties, there's a question here. You know, it's a bit confusing when participants have questions in the chat and the Q&A as well. So the question was, first it was a thank you for the webinar. Should Kenya be enforcing the copyright of, say, foreign musicians like Diamond or Jerusalema, yet Tanzania and South Africa do not remit royalties? So I can't see the rest of the question. Do not remit royalties. Okay, I can't see the rest of the question.
Okay, the thing with royalty collection and CMOs is this, in my experience in the CMOs before, was that first, we are a signatory to the Berne Convention, and so there's a principle that how we treat our own rights holders, we should be able to treat other rights holders like that, But CMOs worldwide would go a further step ahead and sign bilateral agreements with other countries. In the music space, I know that they would remit monies back and forth. Other countries, whatever they collect for you, they'll remit whatever you collect for them. That should be able to work, but it's easier to work through CMOs with such things, unless you are willing to do that by yourself, because the whole idea of CMOs is that they're supposed to monitor use of works for their members who are rights holders, negotiate licenses, collect royalties, and distribute them. in the absence of CMO, you're supposed to do this by yourself individually. So you can imagine if every musician went to all the matatus to monitor how their works are being used, then you're paying every musician. It's really impractical and almost impossible. So that's the whole idea of having CMOs. Let me tie that question to another one I saw in the Q&A about someone asking whether their work would be copyrighted here, whether it does apply globally.
Yes, it was James. It was James who was asking if he gets his creative works copyrighted in Kenya, does that copyright apply globally?
Okay, so first we need to know that registration of copyright is not what gives you copyright.
Mm-hmm.
Copyright is almost automatic, and like patents. Like for patents, I have to register a patent. That's when I get the patent. I have to go to KIPI, do whatever I need to do, register the patent. That's when I get a patent. But with copyright, I just need to fix the work. So if today I woke up and went to a studio and sang a song and it's out there, I already have the right. Copyright already gives me the right. It is fixed, it's out there, it's fine. Registration is usually just a step further. Like in Kenya, it's provided for in our act. There are jurisdictions that do registrations, others don't. Yeah.
Mm-hmm.
But when it comes to enforcement, you would have to go do enforcement in every place. Like if it's being infringed upon in Kenya, then you have to come and sue here. You can't expect that it will be automatic that things will just work. If it's being infringed upon in Uganda, I would have to go to Uganda and sue there. But on the issue of royalty collection, whatever CMO I have here should be having an understanding also with another CMO in terms of remitting monies, if that's what they need to do. But the principle of national treatment means that how they treat rights holders of Kenya here, you also need to treat foreign works that are within your borders, because you cannot live by yourself. You're not an island. So you definitely have foreign works here. So if we say we are disrespecting foreign works in Kenya, that means they'll never come.
Okay, thank you.
Someone had also asked something, Helen, on...
I found those two questions, Sharon.
Yeah.
So the first one was from Kelvin Gishia, an animation student here at USIU. When one creates a character specifically in animation, can you hear me, Sharon?
I'm hearing an echo.
You're hearing an echo?
But maybe it's
How about now?
Okay, I hear you.
Okay, so when one creates a character specifically in animation, what can be copyrighted? The character themselves, the name, the art style, or the personality? That's the first part of the question. And then the second part is, how much is the use of an art style considered infringement? And then there is a question again about what is the process of, I believe he meant to ask, what is the process of registering the copyright?
Okay, I'll take the registration question and then Liz can talk about the other questions. Is that okay, Liz?
Yeah, sure.
Okay, great.
The process of registration has been so easy with the Copyright Board. You have categories of works that you can register for copyright, which are literary, artistic, musical, audiovisual works, and then software and computer programs. So we initially, when we were doing physical registration, you'd come, fill a form, give a sample of your work, two copies of a sample of your work. So if it's a CD, musical CD, you give two, and we do the process. Then we moved online. We had a registration online, but recently we have a new platform. It's called the National Rights Registry. It's a new platform that is online. The website is NRR, National Rights Registry .copyright.go.ke. So if you go to that platform, you'll be able to create a profile to sign up, register yourself, and then once you're in, you're able to upload your works. It will give you the different categories, whether it's a literary work. Maybe I must mention that on that platform, software like apps and computer programs, they're put under literary works. So whether it's a literary work, musical, audiovisual, sound recording, you're able to upload it on that platform. This is a new platform that we have been working on together with CMOs and the ministry to make sure that we capture details of creators in Kenya. This platform has 3 different modules. One will be for CMOs, one for distributing, one for payment, so that it can monitor your works, the use of your works. It can calculate what your royalties are, and then people will be able to be paid going forward. This is a very new platform. I think it's hardly a month since we unveiled it. But for now, we are telling people to go there and register. This platform has waived the fee. Initially, the registration fee would be 1,000 per work, the work that you're registering. So if you have an album, a CD, and you're coming to register that CD, you would have to pay 1,000 for that. This new platform has waived that fee so far, but it will not be like this forever. So whoever has any works and they need to do registration, probably this would be a nice time to do the registration. I feel like the whole animation question is more on Liz's realm. So let's Liz pick that one up.
Yeah, so Liz, while you're answering that, there's a question which I think is right up in your alley. How does a musician protect his songs, and how do they get paid for the views and likes on their songs? That's also from a student here at USIU called Caleb Onyinge. Thank you.
Okay.
Yeah.
Let me start with the music one because it will have a lot less stories than before I tackle the animation one. So an artist, how do you protect your song? So number one, have a music split sheet that captures who are the authors of the song. So the author, composer, arranger. Those are the 3 rights holders in copyright in a song. So if you're going to write it with a friend or collaborate with a friend, it needs to be clear who those, among the 3 in the copyright, who owns what, and allocate each other, your percentages as you find it fit. Now we have been doing a lot of hybrids of split sheets because artists are saying, oh, we need one document. So then you divide it into the different categories. You have the copyright and the related rights section. So again, we'll go into the performer section and say, okay, did I write the song alone? Okay, fine. Then that means I only have copyright. So in the related rights as a performer, I have no right. So then I will now just capture who sang, who did the rap, is there someone who played the instrumentals or the track producer, have that also captured. And then at the bottom, have the issue of the sound recording rights, who owns the master right to the song. To Melipa 15,000 in the studio, we need to have had a conversation with the producer or the owner of the studio, what that 15,000 was for. Is it that we are going to co-own the master recording, or does he retain the master recording right because I've only paid for studio time? That conversation needs to happen. It needs to be on a contract. And again, CAMP's greatest issue has always been that some of the producers have no contract. So I think artists need to start having those conversations because that is where you start. Again, without this split sheet, it becomes very hard to attract either a filmmaker or a game developer to come and say, oh, I want to use your song in a film or in my video. Wapi split sheet. The person is like, what is that, right? And that's your title, right? Your title. So that then even this person who wants to use your work can know that I know there are 3 people involved, these are the people I will be paying. I'm using this work for the next 3 years, right? When there's no document in place, they're just like, let's just go and work with South African artists. They seem to be more organized, right? So that's why we start with the split sheet. Then when you put it online, when you put it on YouTube or any digital platform, you need to create content ID, content ID identification, where it identifies who you are as the artist and all that stuff. And like YouTube has this fabulous infrastructure that once you upload it, they also mirror it, so that then that's how they monitor and track infringement, right? Then they're able to flag and say, this content is not yours, belongs to X, Y, and Z, shut it down or take it down before we shut you down, sort of thing. So, but content ID is very important because it's the identification your content or your music will have online for you to be able to, figure out what's happening to it. Again, when you upload it on YouTube, on the back end, you're able to manage permissions and say, you know what, anyone else can do renditions of my song, but redirect it to my channel or on my platform so that any monetization that happens, it is mine because it's my work. That's why, again, I said permissions then become important. If I invest heavily on a cover song to have that conversation, then I can make 20% when the original author, if they wanted 10%, 90%, they have it. get something. So, content ID is very important online. And then again, it's very important to know the kind of business model these platforms have. Some platforms will pay per eyeball and say, you know what, because their views, I will pay per eyeball at 0.05 cents or whatever. Some are now paying based on how long the viewer will watch the ad. So if the viewer doesn't watch an advertisement throughout, then the channel owner will not make any money until they can show that 50 viewers today watched that, I don't know, USIU ad about their new programs, for example, right? That's when so even USIU, by the time you're putting an ad online as well, you're like, have they interacted with my advertisement?
Yes.
So all that happens.
Very important.
So, and I think creatives need to really understand. So, if you have your stuff online, be aware of what platform it is, how are they going to compensate you. Then you tell your fans, when you're on my channel, please make sure you watch the ad because I'll get paid from the ad, right? Because subscribers are not, paying anything to get access. So I think that is very important. So split sheet and the contract, if it's a hybrid split sheet, have it done. That is where you start in terms of protection. So now the question of the animator. So number one, what does copyright protect? It protects artistic works, literary works, audiovisual works, software. There is nowhere it talks about techniques. And I said that earlier, copyright does not protect techniques, does not protect business models or any forms of ideas in their raw form. It's about expression of the ideas as outlined under Section 2 of the Copyright Act. So no, techniques are not there. So if you will contribute to the body of how to draw cartoons and whatnot, thank you, we appreciate, because that's how IP also works. It's not just about own, it's also about creating solutions, right? So now, you've created this animation, this fabulous cartoon, how do you protect it? There's the artistic work element of it, the drawing of itself, that is what you will protect under copyright. But copyright does not give you does not protect words, right? Because now words are name or whatever fancy, branding that you give this cartoon, then now you need a trademark. So for example, Mickey Mouse, there's the artistic work for Mickey Mouse. Then there's Mickey Mouse TM, trademark, right? So you register the trademark. Now what happens when a commercial entity decides to pick your cartoon and put it, on an advert or in a film or whatever, because now this cartoon has acquired some personality, then now we'll be talking about, common law rights of personality rights and whatnot. Then, we'll be going after this particular entity for using that cartoon because they would misrepresent that they're either working with this particular entity or they represent, corporate X in that advertisement, for example. So, but the good thing is in animation, once you create this cartoon and you're doing all this fabulous stuff online, they acquire that personality so they can stand on their own. They not just become a property owned by Animator X. So then, you can actually now license it and say I created cartoon called Jemo. So Jemo can, I can license out to Jemo. Jemo has certain personality rights. So if someone else decided to use the likelihood of Jemo and anyone who interacts with this material can say, hey, that's Jemo that was created by Liz, right? Then I have some rights. So some of them might not be intellectual property per se, but then now there'll be issues of, personality rights and common law issues about passing off and things like that. But yeah, the basic is, copyright the artistic works, trademark the name and whatever fabulous branding that you use. And I think it's always important, even just for our animators, to look at how the different people, creatives outside Kenya or in Hollywood are doing, right? If you look at Harry Potter, there's Harry Potter, the trademark, right? So because copyright just expression of the book, the stories, then Harry Potter to create a trademark. And then again, the strategy of the trademark, what else are you going to do aside from, possibly having a film? Am I going to go into merchandising? I can see merchandising is fabulous. So I need to, declare the class, for clothing and apparel and whatnot, so that then I'm protected. Because if you do not declare a certain class, then someone else will come in a different class because you're totally unrelated, right? So yeah, I think I have answered that question amply.
Helen, maybe to pick up on what Liz is saying, we can mention that sometimes you will find a work crosses the lines of different intellectual property rights. So you may find a work that could have a trademark, it could arise a copyright out of it, could even arise a patent. So sometimes it's good to, in your IP management of the IP that you have, it's good to assess, to try and assess whatever you have in your works, what IPs can arise out of this. It's allowed to have more than one arising out of one work, which is still okay. You may have a trademark arising out of it, you may have copyright out of it, you may have a patent coming, you may have whatever. All this you could find they may arise out of one work. So that's also usually possible. You need to still assess what work you have and what IPs are arising out of it and what you can register. In the past, I have found that most people found it easier to register copyright because it was an easier process and cheaper before they now begin maybe a trademark process or whatever, which is still okay.
Okay, I guess both your what you've said and what Liz has said responds to this question that was about how trademark ownership in Kenya relates to copyright law.
Okay. They are related. It's just that, again, remember, trademark, you have to sustain it. It's protected for 10 years and you have to keep renewing it.
Renewing the protection.
Yeah, so after 10 years, you renew the protection. Okay, you can do that for as long as you want. If you renew it before someone else runs to do it again, yeah, but generally you can do it. But again, with copyright, it seems to give you a longer time because it's basically your whole life. And then 50 years after you die, in some jurisdictions, it's actually 70 years after the death of the person.
Okay.
And just to reiterate, trademark, we're talking about gaining the exclusive use over a name, a symbol, a slogan, or any creative whatever, right? So just because I registered my copyright for a book called Harry Potter. You see, Harry Potter, how many Harrys are there? The good thing is now on the trademark side, I'll be able to say I am registering Harry Potter as a trademark in the class of books. Possibly now, again, like Sharon said, you have to sit down and think about your IP management system and strategy, right?
Yeah.
Because you create something and you're like, I want to do video games, I want to do, or there's potential for that. Then now in the trademark side, you lock it down. Because now with trademarks, there's a lot of trading because it's issues of trade. There's even more money and more clout. So trademarks actually have a lot of, they are very valuable, right? So you can imagine trademark plus copyright, like you've created an empire, right? But you need to have registered and have, sort of separated all these entities or other assets, and then now you can actually commercialize. And the good thing with trademarks, you're even able to, sort of different entities can be licensed for the different marks that you create. A book tends, like for example, with a book, they create so many things. If you look at the example of Harry Potter, she came up with so many things inside the book. She came up with a game. She had very interesting words. She was giving things, all those things, trademarks. That's why J.K. Rowling now is a billionaire, rags to riches sort of situation, right? So, and I think she's the best example of what an IP management, an effective IP management strategy would look like and how it would, build a creative.
So would you say, because there's a question or an observation that Andrew Balong or Pere made in the chat, but I can't get it. So Susan, if you can get it, you can.
Was it the issue on economics, the role of economics to support IP?
Yeah, in terms of, would you say then in the West, there are better structures? They are more resourced or enabled as artists or upcoming artists to protect their IP. Would you say that is the case?
It's not the case. We have the same structures, we have the same infrastructure, we have all signed to the same international conventions and whatnot. I think our biggest challenge is that now we either engage people who do not appreciate the value of intellectual property. We are always trying to cut corners and, I've not investigated who I'm trying to do business with. Do they understand? Will they, be able to value my work and figure out how I get to the next level? That is our problem. Our problem is personnel. You remember initially I even said, our industry has a lot of urafiki, ubeshte. We are buddy. We are not doing business. That is the difference between us and Hollywood and other, developed industries and economies. I'm doing business with my mother. Sawa, you're my mom, but we have a contract, right? We have so many of these empires abroad where parents and kids are working together, or sisters and brothers, family members, but they have contracts. As I know, we are Africans, tunapendana, it's for nini, but yeah, that's our challenge. And you see, the minute you start having, the minute you start engaging someone and you talk contracts, you also, you're putting them on the spotlight to start thinking about what are these what is the economic situation, what are these rights we're negotiating, what are we looking at as projections, what is our business strategy. That is the thing we lack. It's about figuring out who we work with, why are we working with them, do we have the necessary structures. That's why I said from the beginning, then we need lawyers, you need an accountant, we need to stop these peke yako productions we have as Kenyans, right? You run your movie company, then you want to draft your own contracts, you are the one again who's going to cast for your film, you're the one running there to get licenses, you're the one clearing music, like you're doing everything. At what point, will you even be able to sit down and think about the legal implications or the business implications of what you're trying to do? So Pekiako Productions needs to stop. Share the pie. The pie is huge. Get the expertise that you need. I need a tax accountant. He'll be able to help me. Do I need a rebate from Gavag? Tell him to go negotiate that for you. If it's a license from so-and-so, you have someone in licensing to go and help you get a license from KFC. From whoever you're going to use so-and-so song in your film, they help you do that. Again, you reduce your liability, but you are expanding the value of what you're creating. The share, the pie becomes bigger and we can make some money together. Instead of trying to just kula peke yako, it's about systems. That's the difference. We don't have systems and we need to start having systems. Don't start saying, Liz, 100K ni pesa mingi. Instead, say, Liz, I have 20K now, but this film has potential. So I was thinking, I can either pay you pole pole, or when the new film launches, I know the money will come here and here, chukua. And maybe I will say, you know what, give me 80K and I want what's it called? I want credits to say legal by my IP legal studio. Win-win, right? So it's about US is not doing anything different from us, right? It's just that sometimes also, again, we have that thing where we're like, Mzungu will do it better. Then Mzungu thinks, hey, this Africa doesn't know much. Then, because you've also not done your research, it's very easy for stuff to be misrepresented to you. Then you go saying they're stealing from us. But you also didn't own up to your own, pitfalls to say, anyway, I didn't do my research, I don't know anything, and I accept. I am the one who took myself to the, kichinjioni. I went to the slaughterhouse myself, right? So there's hardly any difference. Yeah.
So would you say, yes, Sharon, go on.
What she said, one of the questions that creatives, and let me say artists in Kenya need to ask themselves is, how do I make money out of my work? Which is something I think most people have not done for a long time. Initially, it was like, I'm gifted, I know how to sing, or I like to sing, it's a hobby, let me do this. Or I want to be a professor, let me publish. And so the reasons that our people for a while have used to create were fame, whatever else. But it was never money. But now we have gotten to a point where people need to begin to ask themselves, how do I make a living out of this? If it means getting to know what I need to know to tie in economic support to my IP, yes, I need to do that. We need to move out of the complacent place of saying, okay, songs never pay, films in Kenya never pay, acting never pays. No, they now pay. Begin to ask yourself, this is property. Am I looking at my property like my house, like my car? We are very proud when you have a shamba in Kitengela. You're always happy when you have a shamba in Rongai. You're telling everyone, I have a shamba. Why aren't you telling everyone I have this intellectual property? Because you're not seeing it as valuable. And I think that's where the role of economical support and IP needs to come in. We need to have a lot more information and education around the issue of economic support and intellectual property, that intellectual property can actually make your living, make money out of it. I like to use John Grisham always as an example. Dude was a lawyer. He discovered you can write legal drama and sit down and just let the book sell. Sold in millions, sold in millions, sold in millions. I can take a vacation for 3 months and sit on a beach na andika kitabu. Come back, sold in millions. You understand? He would be stuck in court corridors akipigana na watu huko juu ya IP and whatever else. But his books are making money. He discovered I'm a lawyer, yes, but I'm good at writing. And then I'm writing, I'm bringing court into book, and it's captivating and people love it. Come on, let's do this. Let it pay myself. Let it make money, and it has. So I think that's what our people need to do, creatives and artists. Ask yourself, how do I make a living out of my intellectual property? When you begin to do that, I think then we begin to move ahead in this space.
It also goes back to what, it also goes back to what Liz said about packaging. A simple example, when you go to the butchery, umepewa nyama, umekatiwa, they don't just give it to you as is. They wrap it, you put it in a bag, and then you're given. When you go to the supermarket, products are not just there, chukua njugu, like it's put in a particular compartment or a box, and you can see it has the details. This is what's in this box, because they've refined the process of creating the product. So looking at your creative work as a product, and also realizing that registration and protection is also based on use. What do you want to use this for? What's the anticipation? What are the future projections of what this can be? It can be on a t-shirt if it's a photograph. It can be in a movie if it's a song. So how are you appealing to those people? In a supermarket, you'll see you buy a product based primarily or initially on the way it looks. So packaging is also really good to keep in mind as you're creating. A lot of the times creatives think about, oh, I want to do this thing, I have this concept, I have this idea, and then you create, and then you're like, oh, I don't have the know-how, the legal know-how. Oh, I don't have this, I don't have that. So it's good to keep having these conversations and think further than I've taken a picture. Okay, I've taken a picture. What next?
Yeah. Helen, I had a question on joint authorship I would like to refer to. I think it's from Sheila. What she's calling co-authorship. It's really joint authorship in copyright law. So copyright law recognizes the issue of joint authorship, meaning me and you can come together and decide we're writing a book. And you've seen many books. One of the ones I like, Boundaries by Cloud and Towson, yeah? So two people who are, I think they're psychologists, they come together, write a book. So if you look at the law surrounding joint authorship, it's allowed and joint authors are recognized. And the courts have in the past held that you don't have to do 90%, you don't have to do 50, I do 50 for this work to be said to be a joint work. It's just that if you remove my contribution from that work, then it would significantly alter the work. You understand? But you could do 80, I do 20. But my 20 significantly, if you remove it, can alter that work to change it to something else. With joint authorship, usually, because you're saying if someone dies and they haven't transferred the rights, no. With joint authorship, you both have copyright in that work. So if I die first, you continue, the copyright continues subsisting, yeah? The moment the second author dies, then you begin to count the 50 years after that is when copyright will lapse. But you have equal rights. It's not like, oh, I need to transfer the right to you if I died or before I died. No. In a joint authorship work, in a joint work, both are recognized as authors. But also one of the things, Liz has mentioned this, I think 2-3 times. We in Africa need to stop this gentleman agreement thing of just tulisikizana, tukasema, we came together, I said, let's do. Let's have a written agreement from the beginning, yeah? I'm doing this for you, you're doing this for me, we are doing this together, how does this work, what are the royalties, whatever. In the past, when I worked for CMO, I dealt with literary works, publishers and authors, and issues I had all the time with authors would be like, oh no, this publisher has really fingered me, and I would go back to nipatie contract, what you signed with them. And then you find they basically signed away the copyright to the publisher. You know, they signed this contract that said, okay, the publisher says, since I'm putting in the money and whatever, yes, you have the money, but you have no content. So what will you publish if I don't give you content? You understand? So authors had been made to think that the publisher is the main person in a book. Yet the author has the content, the publisher has the money, the publisher is the business person. And so I kept telling them, it goes back to your agreement from the beginning, the contract. What did you sign? What did you agree? And when you ask people, most of them will be like, oh, or I took my manuscript, I showed these 2-3 publishers, wakakata, and the next I saw the book in Helen's name. Did you have an undisclosure agreement? No, see, we just said you read Kwanzaa, you'll tell me. People need to begin, in Africa, we need to become professional. We need to become professional. We move from, Liz is my friend, I know Liz. Liz, fanya hivi, kwa ukinifanyia hii, we will agree when the money comes in. Negotiate, negotiate, negotiate. Then have written agreement. Agree. Agreement means agree. Tumekubaliana. Have a written agreement. Spelling out everything. If money comes, okay, say hakuna pesa. When money comes, this is how we are sharing, whatever. Because that's one of the biggest issues I have constantly come in. And especially for me, then it was authors I dealt with a lot. They'd come crying about publisher eating their money and whatever. And when you look at the contract they signed, basically they signed away the whole of their
rights.
Publisher. And then they agreed that they'll be given a mere 3% of the sales or something like that. And so they keep wondering, why isn't this book giving me money? So I think that's another thing that we also have to learn to do. Be professional, put our things in agreement and in writing, and have them solid, and move away from the gentleman's agreement.
So would you say we need to make a case for more interaction between lawyers and artists in the creative space?
Oh, sure, sure. That's one thing, by the way. As Liz had put it, she put it so well. You can come to me and say, okay, this is what I need. This is my work. I see potential in it, but sai sina pesa. How do we work through? You understand? Then we work through something that's win-win. These lawyers are also just human beings like you. They also have probably law firms. They started as you. They started businesses from scratch like you. So they probably understand where you're from. The only difference is that they have the technical know-how, which you don't. Yeah. Like if now someone decided, okay, I'm getting divorced, I'm filing my papers by myself. You run to court and file. You do not know anything about family law. You don't even know what reasons you can use in your plaint, in your divorce petition about it. Then you just go and say, oh, my wife didn't smile at me. She didn't cook. She didn't. Those are not legal. You'll be told, can you be serious? It is easy to find someone who can do that work, who knows it, and you also gain from it. As Liz said, would you rather fight for 100 bob or fight with me for 1 million, and then you give me 20% of it? You get, you will still get more than if you're fighting by yourself. So I think the assumption first has been that legal services are expensive. Yes, they can be, but then again, who are you dealing with? Who are you talking to? It is the same way you can say, mimi siwezi kwenda Serena ninunue chai ya 500. Someone else says, I can. Someone else says, hey, me, I can't go to Java, mi naenda tu Kibandaski. Sawa, you will go to Kibandaski, buy your chai for 20 bob. Someone else can go to Java, buy their chai for 200. Another person goes wherever. So you have all these options, but you need to get to know that it is easier and better, and it will probably work for you better to have a professional do some of these things for you. I even saw a question, someone saying, can I just do this thing by myself other than looking for a lawyer's G to do what? Was it copyright registration? I don't know. Yes, there are certain things you may end up doing for yourself. You see, like for us, we have created a platform, the National Rights Registry, where it's easy for an artist to just go register and then upload your work. Sawa. Some of those things, yeah, they're quite basic and they're easy to do. But then some of these other things you may benefit more. Well, imagine if you sat down with an intellectual property law expert and do your IP strategy of managing your IP, they're able to identify for you, okay, from this, you can get a trademark, you can get a patent, you can get this, sasa tuanze wapi, tuanze hapa, then you do this, and help you grow and help you make that money. It would work for you better than to say, okay, I'm self-producing, I'm self-singing, I'm self-whatever. And that's the other issue Kenyans have had. You see, like in the issue of music, one of the problems Copyright Board has always dealt with, people kept saying, why do we have all these organizations collecting? And then you have to keep coming back and say, okay, you see in a song, you have different rights holders in that song.
Mm-hmm.
I have a performer, I have a producer. And the problem has been in Kenya, performer, producer, director, ni mtu mmoja. The composer, the author is one person. If you go out there, you'll find people like Mariah Carey. You'll be surprised. She never writes her songs.
Mm-hmm.
There is a songwriter who, and I went to this course in London, and one of the people who came to talk to us was a songwriter. And their job is to write songs. But you see, when they're writing songs, they're saying, Sharon has an alto. Okay, so this song, I'm writing this for Sharon in mind. If Sharon brought out this song, it would be nice. Oh, Liz has a soprano. Liz akiimba hii haitatoka vile nataka. So there are people whose job out there in Europe and out there, their job is writing songs. They may not be able to sing themselves.
Yeah.
But here in Kenya, all of us are a jack of all trades. You're the producer, you're the singer, you're the writer, you're the marketer, you're the distributor. It sounds cheaper, like a cheaper option. But in the end, it works on the negative in that you're not able to commercialize this, your creative works well, you're not able to gain as much as you can out of it.
Thank you. So ladies, we have 3 minutes.
Ooh.
This webinar was to end at 4. Do we have time to take maybe like 5 or 6 more questions, then we close out because this has been quite an interesting and educative session. So I don't want to lock out those who had questions to ask. Susan, I'm not able to get all those questions, so could you just pick them out?
Yeah,
I believe the ones in the chat have all been answered. Yeah. So
I've tried to answer some by typing the answer there, so I hope it works.
oh, okay. So we could take 5 more questions, then we'll close out with, I'd like to hear your views, my 2 facilitators, on the disquiet, the recent disquiet in the creatives industry over how they are treated, because in a way, to me, it seemed to speak to issues of, is there, I don't want to call it regulation, but I'll have to use that word. How do you regulate relations within the creatives industry? Do you fall back to employment law, employee-employer contractual relationship, or is there a need for them to have some sort of like union, or do they have one? Does it already exist? And I don't know. Yeah, I would like us to close out with a comment from the 2 of you on that issue after we answer the 5 questions.
Okay, so Mina Gashoya has a question. I have a question on the recording process. When guys are involved in a creative process, say recording a song, at what point do they negotiate a contract, especially for those claiming related rights? And when is the split sheet introduced?
So let me start with that. We answer as you ask, so that then chap. So I always tell guys, first of all, once you've started the process of creation and you figured out how the song looks like, that is the minute that you introduce the split sheet and say, okay, we've done the rehearsal, because you don't go and rehearsal in the studio. The rehearsal in the studio, it costs more money, right? So where you've been doing your things, you see that you sang the song, it's perfect. And when only Andika bridge, I feel like this is 50%. Then we negotiate, because already now we've seen what a structure of a split sheet looks like. Even as we were creating, we had a conversation and said we will have a split sheet so that we agree on who owns what and how, right? So that by the time now we have, we've done the run through, we know when we go to the studio, this is how it's likely to look like. We have the first draft that says, okay, Susan wrote the lyrics, so you're the author. I think you deserve 30% because now I'm the one who came up with the melody. I am the composer, Then so-and-so said, no, I arranged the music, I helped you figure out how we will do the ad-libs, blah, blah, blah. So maybe I didn't write the song, but my creation, my contribution was the arrangement, right? And we are aware of this, because again, the problem has been the awareness. So then now we have that split. So that should we go to the studio, there may be minor changes, because maybe you go to a studio where now the producer is also, has a music background, and then they're able to say, oh, but this doesn't sound right, then this and this changes, right? So then if this producer again now has come in as an arranger and has sort of helped you arrange the song, maybe changed a few lines, hapa na pale and whatnot, then you realize and you recognize that this guy also now has some stake in the copyright, have that conversation, and then, so by the time you are done, recording the song, that thing should be signed. See, we wait for after 2 weeks, oh, no, let's just release the song, we'll do the split sheet later. Nobody ever wants to sign a contract after the fact. It's like the hardest thing to enforce. So I always tell guys, you do it from the beginning, because things will change, things might change, and the circumstances might be different. So it's something you do in the beginning. When you hire a contractor, you give that contractor that contract immediately. Any amendments will happen after, if he says, oh, but we realized Cochini, there's a water pipe, so we might have now to change, and we'll have to buy more material, so that the things that change, you can either do an addendum or whatever, but have that contract from the beginning, not after the fact.
Yeah, be proactive, not reactive.
Yeah, proactive, not reactive. Same thing with the producer. Hey, dude, you've asked for 15K. Your 15K ni anini. Like, don't start assuming now I have the master recording rights for 15K. It's not possible, right? The studio has expenses. There's a sound engineer, he's paying a salo, there's steamer, all these things, all that business investment. He's figuring out how he will recoup his investment. So those conversations need to happen, and a contract is signed. Immediately you agree, mwandikiane, right?
Okay, thanks for that. Michael Mbugwa has a pretty long set of questions, so I'll go to the few that are at the bottom. I think the first one was answered by Sharon, but he's asking, is registration with Kenyan bodies advisable? Do they really pay? Also, is there geographical boundaries for copyrights, or if we own the right locally, even if it hits anywhere in the world, the company will still own the profits from this? And if anything goes wrong, will litigation from this end work anywhere in the world? Are there any tips for similar companies that people usually forget about or they should consider?
Sharon, do you want to take that?
He talked about litigation. Well, litigation, you have to go to that country where the infringement is happening. Because remember, so states are sovereign, they have their different laws, how they work. And so you have to go to that country and do litigation there. What you would be weighing here is it worth it financially to go to America and try to sue someone there for infringement? Itamaliza pesa yako ama itakuletea pesa. You need to really weigh with anything to do with litigation, whether you need to go and do that. But litigation, you have to go. If the infringement is happening there, then you have to go and do the litigation there. Maybe I can also mention, no, copyright law doesn't work by itself. It has to work in tandem with all the other laws. Yeah. So like when we were doing copyright prosecution, you would still have to go back to the Criminal Procedure Code, you still have to go, the Evidence Act, you still have to go to all those laws to comply with their bit of it, even though your mother complaint is mothered or hinged in the Copyright Act. So you have to look at it also from that. In terms of infringement, you have to look at the law as a whole. What was the other question?
There were a series of them. Let me just, so there is is registration with Kenyan bodies advisable? Do they really pay?
Well, for me, I would think it's a good thing to register with them. By bodies, he means CMOs.
Yeah.
Okay.
I believe, yeah.
Well, I think it would be a good idea to be a member of a CMO, because it's not always easy to do monitoring, collection, and whatever by yourself. So mostly the whole idea of CMOs is that it's impractical and almost impossible to monitor use of your works, to license them, to collect royalties by yourself. You can imagine as myself, I have to go to every hotel, I have to go to every matatu, I have to go to try and license for my work. It doesn't really work. So that CMOs generally make it a little easier. And for me, the way I look at it, it's also a place where you can network with like-minded people, other musicians, meet people. That's where collabos are born, whatever. Yeah. So it's always a good idea to come together. The issue of management of these organizations is also another issue altogether. But for me, I believe if I want to see a change, I become a member and try be the change that I want it to be, you know.
Yeah. And I believe that Sheila Mulenya asked a question about co-authorship, which I think you answered, Sharon.
I answered it on the issue of joint works, yeah, joint authorship.
There's an anonymous attendee who is.
Yeah, can we have? There was the, you know, Liz, we didn't really speak about sportsmen and women. So if Susan, you could take this question, or I could ask it. Are sportsmen and women considered in the category of entertainers? If yes, what rights do they have in terms of property rights? This is from Halima Bakari. She's one of our sports women here at USIU.
Okay. So yes, sportsmen, sportswomen are in the category of entertainers. They are commonly also in the bunch of celebrities. They are celebrities, right? So anyone who's popular, well-known, they have celebrity status. Now with celebrity status comes image rights, and image rights is twofold. We have publicity rights, and we have personality, or rather personality rights under the realm of publicity rights and privacy rights. So privacy rights would just be, you know, someone to kawaida, my picture is just used, I was at an investor shop, for example, then someone takes a picture and I find myself on a calendar. That is an issue of privacy rights. And I could alter it and now argue some sort of publicity rights because they're publicizing my image to make some money. So with celebrities, then they really can't argue. It becomes very hard for them to argue that, oh, because of privacy rights, you take something down, right? Especially something that could make money. So then we convert it into a publicity rights issue and say, okay, I'm Eliud Kipchoge, right? I am worth 5 million Kenya shillings. Brand X has used me on an advertisement, or they have used me on a calendar or whatever. Then they compensate me on the premise of personality rights. So personality rights are under what we call a common law right. So they're not per se on any legislation really, but they arise from common law. So that now where you're not compensated, we'll be talking about issues of passing off, that you are representing. You're misrepresenting to the public that I work with your brand, yeah? So then I sue on that premise. So I wouldn't really be suing for image rights, but now I'll be suing under the thought of passing off, that you're misrepresenting to the public that I have endorsed your brand or I am working with your brand. Yeah. That's
Thank you, Liz. Yeah, because that question was asked, we had a question at the last webinar. On the issue, somebody talked about taking a photo using the university camera. Who owns the copyright of the photo? When you take photos during functions like graduations and uses them, say newspaper articles or on social media sites, who owns those photos? The camera person, the subject in the photo, or the publishing house? And I want to take you back to the beginning when I talked about the beauty industry. So I run this business where I do this work, and in order to advertise my work, once I finish, let's say, doing your hair, I post that on Instagram, on Facebook, and I didn't seek your permission to do that.
Yes.
Should I feel as the model? Should I feel like you have violated my rights and actually profited from what you have done?
Yeah, and you see, like in that instance, it's an issue of privacy. You came in your capacity in your privacy capacity, come make my hair, and I move on with life. So the minute then I take an image of you and put it online, I have infringed on your privacy, one, to begin with. And then secondly, I'm benefiting, I'm publicizing your image to benefit. So then I should then pay you. And I usually tell guys, sometimes you may not have the time to get a pen and paper, right? Like in this instance. But then, see, we have smartphones. So all I need to do is say, Helen, you like your hair? Even me, I like how it looks. But now I want more clients. So can I use your picture on my social media? Yes, okay. Let me record and get your permission on my video. Hey, Helen, you said your name is Helen who? My name is Helen. Are you okay with me taking this picture or not? Sawa, stop. I recorded it. I can even send you a picture of that video. Then I take the picture and put it online. That's a contract. We are good to go, right? So I think people need to be very aware. And you see, image rights also goes into issues of image likeness and that personality. So for example, I do a book and I describe this character so well, and people know I'm talking about Wangare Maathai. Yes. Then I have to go to her estate and clear those rights, because that is an issue of image rights. We're talking about issues of publicity. There may be even to some extent privacy issues, because maybe you're raising something that they want to be forgotten, or whatever. Because again, they will have some rights, purposes of time and not to complicate things, but they will have some rights. So it's always important that people are aware that issues of image rights are there. It can be in the use of this image in itself, or the likeness of it. The minute I turn you into a cartoon, there's image rights. I decided to create a film about Helen the lawyer, and people know it's Helen from USIU. Hey, but enough for your money. So image rights are huge. It's just a lack of understanding, and even corporates, because they don't understand it, they misuse it. But those who have been smart, we've seen very good cases where there've been settlements out of court of good money, and then under confidentiality they never talk about it, because also when we talk about it, then they feel like their brand will be, their brand presence will be crushed or tainted or whatever. So then they seal it under confidentiality.
Okay. All right, so I think that sums it up in terms of the questions that we were going to take. Now I'd like to hear your views on this disquiet in the creatives industry.
Sharon, do you want to start?
Let's start.
We're not deferring to seniority today.
Okay. So I think for purposes of the audience, we're talking about the conversations the film industry has been having about, ill treatment, let's just call it ill treatment in a nutshell. Now, this is my view. Our industry is in a place where we can no longer argue that we do not have information, because we have so much information out there. Just the power of the Google search as well is enough to say, for you to figure out, party X has given me a contract. I write a script. I write scripts. What do I need to sort of be aware of in a nutshell, right? So, I need to do research on who am I engaging with in terms of this contract. Is their company international? What are they known for? Like, we're not in that place where we investigate. We just hear money and we go running. We don't investigate what the contract says. I mean, I have had clients who, they said themselves, they say, you know what, Liz, I know this is a terrible contract, but I will sign it anyway. And that is the point I tell them, Sasa, this contract means that you're giving away your IP rights. Yes. This means that if they go and make millions, you don't even get a shilling. Yes. Then make peace with it, since you have decided on your own accord, and stop making noise about it. So there are some who have been taking these contracts because they're aware, and then some of them do not believe in their creativity. We have that challenge. We're always like, I can put all this money, but what if I don't make it? But so many other international personalities, and even our locals, there are those success stories who said, you know what, I will put all my eggs in one basket because I believe in this. And boom, they made something amazing. So I think information is not a problem. Information is there. I mean, you just need to go even online and say entertainment or IP lawyers in Kenya. At least will come out. based on that list, how many of your friends work in your industry? Call them and say, hi, have you ever used a lawyer? Do you know lawyer X? Can they help me? You know, do your due diligence. You know, have you ever worked with company X? How did they treat you in that film? You know, are you paid well? Did they pay you lunch? They, you know, provide you lunch and transport? Like that ecosystem, it's about talking each other. And that's the other thing our creatives do not do. They don't talk to each other. One time I had the opportunity to help negotiate a contract for a Kenyan actor in an international film. And I really struggled to get some of the locals who had done similar roles in other international productions to tell me how much they earned, right? So then I realized these guys, they don't even want to tell you how much they earn. Then for us, we struggle with issues of standards. So then now, you know, I had to be creative and assess who is this contracting party, how are we looking at the exploitation. Then we negotiated a figure that I felt would, you know, fit my client. But because here artists are not talking to each other, the creatives are not talking to each other, hatuna standards. A few years back, I negotiated an infringement, an image rights issue with a Kenyan model whose image was used in essay for a global campaign. I ended up using South African rates because our Kenyan association for models and the casting agents had died. They had some, you know, regulations, but they never used to stick to them. So then guys would be like, but why do I stick to the Kenyan rates? And the Kenyan rates are actually pretty good. The South African rates were much lower. So they just shoved their South African rates, and I was like, okay, fine. We negotiated on those essay rates. We got something good in between. But then we are like, okay, Kenyans, hatuna standards. Nobody knows us. So our associations also are not felt. We have associations that have been registered, but some of them are to serve personal interests. You'll find that this association exists because as Sharon, as Liz, as we know we want to get, to work in Hollywood, for example, or get some contracts from Hollywood. That's it. So we get members, we look colorful, but then, it's self-serving our interests. Then members, again, who join these associations do not investigate what is my role as a member, what contribution can I make, how can I be a part of the system, how can I change. It's the same issue with the CMOs. The artists will join the CMO, but the days for AGMs, those guys are nowhere to be seen. It's only the ones who are interested. Of course, the ones who are interested, who are present, their rights will prevail because they were there to champion for their concerns and they voted for them. So the same thing with associations. So when the joint associations read this memorandum and articles of association, what do they provide for? What is the constitution providing for? What is the mechanism of changing officials because we feel like our chairman has been cooling under the table or whatever, all these things. How do we, become progressive with the changes in the business, right? So is our constitution robust enough? Do we need amendments? What does the process of amendment look like? I've seen associations that tried to self-lawyer. They registered an entity and a constitution that had no amendment process. So now they're in a place where now they're just there, they're like, we didn't even provide for payment of membership. We can't vote, we can't do this. So it just becomes so, crazy. It's just one of those things. And I said, again, Pekiako Productions, it's about systems. It's about working together, identifying the different professionals, and then working together, because then if, as an association, you'll be able to say, okay, we have a lawyer, we pay something small every month, so that then our members can go and ask the many questions they have. I have been hired for this, production. What does this mean? Am I a work for hire? Am I an employer? Am I an employee? What am I, what are all these legal issues, right? So, it's about, it's time for active engagement and active purposeful embracing of structures and formalities. Once we do that, I think we will do much better. We have a union of entertainment professionals, which was registered, do you know how many years ago? We don't even know who these officials are. It's never worked. And because of that initial registration, they can't register a new one. So, the stakeholders were told, go back and investigate who are these guys who registered this union. Figure out how you can be members and revive it. If it's issues of employment in the entertainment space, then you can champion for them. But the infrastructures are there, the spirit is there. It's just, I guess, the honesty. We have come down to that place where we are simply talking about honesty. Honesty, and transparency, and willingness to learn, and the ability to say no. If a contract is bad, say no. If you say yes from a point of information, kubali makosa yako, and learn from it, right? Because we need to stop playing the blame game. We all have to own up to our responsibilities, or rather to our contribution to where we are right now. Yeah. I mean, it's true, at some point, it was very hard to do business in entertainment because people believed that, you know, if you are a foreigner, you will bring me more business or you make me richer than if I work with a Kenyan like you, because I feel a Kenyan is exposed. I have not done my research to know that Helen has this kind of expertise, this is the kind of work she has done. Because you are not a European or an American, I would work with you. That has been the practice. It's high time we changed it, right? We will need to investigate the person for their capabilities and not for their nationality or whatever it is. It's now, it comes down to the nitty gritty, you know. So I think that those are, in a nutshell, the things that we are having a problem with. It's about structure, it's about trust, transparency, it's about knowledge, owning up to our mistakes, trying to know the law, and working together. Yeah.
Thank you.
I think, Helen, if I can add on that, also, you need to get yourself to a point where you can ask yourself, if I'm given work to do I deliver? And do I deliver good quality work? And then it's easy to complain that maybe you're not giving me work or you're mistreating me, when I know for sure that you give me work, I deliver within my timelines, I deliver good work. I think that also, for me, in this, let me say in the creative space, that sometimes has been an issue with many people. You will meet people who will renege on their contracts or not deliver on their contracts. And then it's really hard to fight for such a person from that point, because someone else will say, "Wewe nilimpatia kazi afanya, akufanya kazi mzuri," or they didn't do this or whatever. So for you as an individual, as a creative, you need to ask yourself, have I grown myself to the point where, one, I keep my word, I'm honest. If I'm given work to do, I deliver, and I deliver within timelines, and I deliver good quality work. That's another conversation that people need to honestly have about themselves. Sometimes it takes you to introspect to just be able to grow, yeah, and just accept where mistakes have been made and where I need to grow. Then you grow. But the other thing that Liz has mentioned that I would like to agree with and reiterate again is the collaboration and the working together. I've never believed that you're always by yourself, you know, just doing your thing, Mr. Kikujua, what other people in the area are doing or whatever. I think that collaboration and working together is key. When I was in the space of collective management in the area of reprographic rights, that's rights for authors and publishers, I came into contact a lot with the Norwegians. And these guys are so organized. I swear they have like 1 million associations organized. You will get an organization for women's writers who write children's books, Christian women writers, you know, like it is so specific and so organized. Then you will find one person may even be in 20 of this, by the way. One person may be a member of 20. I'm a woman, cool. I'm a woman writer. I write children's books, I'm in this one. I write Christian books, I'm in this one. Okay, now I'm Sijoya, what write? You know, like they are so organized. These guys had authors associations, more than 10. This is a country of just about 5 million people. Very, very organized. And one of the things I saw with them is that because of that organization, they were able to create CMOs that collect money. We are talking about millions of euros. Mpaka, there's some monies they collect for orphaned works or works that they don't know the owners. Hiyo ndio pesa wanatupanga huku Africa. Let's help other people huko nje to build. We have so much money, we have some money hata hatujui mwenyewe. But for me, I saw it's the organization within that industry, within that space. People are very organized. So again, for artists and creatives in whichever space you are, whether it's film, whether it's whatever, organize yourselves. I struggled a lot with authors, publishers. Publishers at least are organized in this country. Authors, it was another case. I really struggled with authors in this nation because they are very disorganized. Some even do not have the info. Some even don't know these things exist. And I'm like, I'm looking at other jurisdictions and seeing people minting money and collecting. Someone had put a question there about issue of singing songs in church. Is that infringement? In Norway, they even license churches for playing music. That's how far they have got. Yes, they license the Ministry of Education for using copyright protected material within public schools. Ministry, Gava, they license them millions of euros. But for me, I saw it's the togetherness, the organization, and the collaboration that really has worked for them. So I think that's that's the next thing I would say. Apart from the introspect of, do we deliver good work in good time, good quality work? Also, there's what's the collaboration? What is the umoja? How are we working together to move this industry? Because there's never one person who will just, move this thing or whatever. You have to work with other people. You have to work. You're not an island. You have to work with other people.
Yeah. So that's the parting shot. That we
My
need
parting shot, actually, I want people not to forget these three things. Contracts. Let's be professional. Let's have contracts. Let's have good agreements. Yeah. Let's have written contracts. Two, for creators and artists in general, think of IP as your car, as your house, as your shamba, as something that can make a living for you. Begin to ask yourself, how do I make a living out of this? Let's move from the realm of hobby. Let's move from the realm of wanting to be famous. Let's move to the realm of, how can this thing work for me and make money for me? Then the fourth one, because I'm a lawyer, let me throw this in. Don't fear lawyers. Get the info. If they have the info, fine. You will always find someone willing to give you the info for less money than the other person. Kuna kibanda, kuna Serena. You have the choice. Naweza kula chapati madondo kwa kibanda, and I could do pizza and whatever somewhere else. You always have a choice, but don't fear. Don't fear. There is nobody in this world who you cannot negotiate with. Don't fear, but get the correct information and the correct help. Then you can be able to turn around your IP to work for you.
Thank you. Thank you very much. This has been a very insightful session. I think for me, the takeaway is what you've just summarized about having a written contract, knowing that your IP can work for you, and what Liz talked about, this pekeako. We need to stop this pekeako enterprise limited and have more collaboration. Because I think with collaboration, you go a long way, as has been articulated very well in today's session. I know we cannot exhaust this conversation. This is just the beginning. And I want to thank you so very much from the bottom of my heart on behalf of the USIU Africa community. We appreciate you taking time out to share your skills and expertise with us in this very novel, area of the law. I usually tell people that even when I sit here as a host or a moderator, I learn a lot from the facilitators because we all can't be experts in everything. There are those who have taken that, have carved a niche in a certain area of the law, and we must be able to interact with them and get to learn what they also know. So it's now 4:29 p.m. and I want to wrap this up. My co-facilitators, moderators, do you want to say something, or do I just close out with this vote of thanks?
Yeah, you can just close out. I'm quite thankful for the opportunity. And I think it's good to also get the information is out there. Liz said it. Learn, educate yourself, and that's it for me.
Thank you so much. Thank you so much, everyone, for joining us. Even the ones who joined us on Facebook Live, we really appreciate. We shall share the recording, as Helena said. Asanteni sana.
Thank you. Thank you, our participants, for being very interactive and asking incisive questions. And to the ladies, like I said earlier today, nobody was going to stop this reggae.
Not even KPLC.
Not even Kenya Power. So thank you very much.